do you have a preference as to who goes first about the order? Or should we go in the order that we have on the program? That's Bradley first, Rodrigo, and Francisca. Is that okay?
Yeah, okay. Yeah,
okay.
That's fine.
Give me a minute. I'm going to close the door. You. Okay, shall we start? Okay, so welcome everybody to the panel on emerging standards in a new global law, views from the global south. So we have three presenters, and I will quickly introduce them when they speak. And my name is Sumudu Atapattu, and I'm at the University of Wisconsin Law School. And I look at the link between human rights and environmental issues, especially climate change and human rights. And I'm also very interested in the North-South debate relating to climate change. So I'm really looking forward to learning more from our panelists today. So our first speaker today is Bradley Condon, who is the WTO Chair, Professor of International Economic Law, and founding director of the Center for International Economic Law at ITM in Mexico City. He has been a visiting professor at the Permanent Mission of Mexico in the WTO, McGill University, and University of New South Wales, and University of Victoria. He serves as a member of the International Group of Experts for the Global Pact for the Environment. He has served as a peer review for Cambridge University Press, Kluwer Law International, Oxford University Press, and various international academic journals. He has published 7 books and over 70 articles on international economic law, including several on climate law. His books on global governance include Climate Change and Global Economic Governance with Oxford University Press, and Global Lessons from the AIDS Pandemic, Economic, Financial, Legal, and Political Implications with Springer. And he is going to, his title for today is Differential Treatment in International Law and Global Risks from Pandemics and Climate Change. So over to you, Bradley. And I will show you 5 minutes more and stop when it's time for you to stop. So over to you. I will mute myself.
Well, thank you, Sumudu, for that introduction. I'm delighted to be here, and especially delighted to be here with my colleagues from ITAM, Chiscapo, and Rodrigo Camarena. I enjoyed the plenary session this morning. I think it gave me some inspiration for my presentation that I'm going to do today. So it's really quite delightful to be here. So as you said, my topic is differential treatment in international law and how that connects with global risks from pandemics and climate change. And I think I'd like to begin by mentioning what I'm going to compare and why. So first of all, I'm going to look at differential treatment in the WTO. So you could say trade law, but the WTO is more than just trade. It's also, very importantly, intellectual property rights, as well as in the climate regime and in the international health regulations of the World Health Organization. And I have to say, listening to the plenary session, it made me realize I should probably ask myself, well, why compare these particular areas of international law? And I would say it's because there are interconnected issues, first of all, with respect to access to technology and the impact of intellectual property rights on access to technology. But also, there's a relationship between trade and climate change and pandemics. Trade routes can spread pandemics. Climate change is expected to increase the frequency of pandemics. And trade, of course, is a source of supply for medical equipment during pandemics and other technology, as well as in climate change, you need trade and access to technology to spread technology for clean energy technology and for climate adaptation around the world. So the three fields are very much difficult to separate in practice on the ground when it comes to how we address these issues. But also, I think it's important to look for opportunities to see cross-fertilization of legal concepts in the three fields, and also to look at what lessons one regime might have for another. And in particular, how do different regimes address common issues? So the common issues here that come to my mind are multilateral negotiation failure and how you deal with differential treatment. And differential treatment is really about how you deal with discrepancies in and diversity among the global North and the global South. Just a word about terminology. I understand that in some areas, one tends to talk about the global North and the global South. In the areas that I'm discussing today, the categorization, for example, in the WTO is developed, developing, and least developed countries. So I'm going to be using the terminology of developed and developing, even though I don't really fully agree with that. And we can talk about that more in the discussion. So first, I want to talk about the concept for differential treatment in climate law, and that is the concept of common but differentiated responsibilities. And it's really a concept that is used to distribute responsibility for reducing greenhouse gas emissions, but also to distribute responsibility for climate finance, for mitigating greenhouse gas and adapting to the climate changes that we're going to have. And it's a problematic category because if you look today at where emissions are coming from, dividing the world into developed and developing countries doesn't make any sense. So the top emitter is China with 10 gigatons. The United States is in second place with just over 5. India is in third place with almost 3. But if you look at the top dozen countries that are responsible for greenhouse gas emissions, China and India together make up about 50% of the emissions in the group. And developing countries as a group make up 2/3 of the emissions. So if we look back on how differential treatment worked initially in the climate regime, it was all about developed countries cutting their emissions and developing countries saying, we don't have to do that because you have historical responsibility for this and we need to develop. But clearly today, we cannot use that approach anymore. And the Paris Agreement managed to get everybody on board, making commitments to reduce greenhouse gas emissions. But it takes a soft law approach, and it hasn't been very effective in getting the rich countries to come up with the money that they promised to help poor countries adapt and reduce their emissions. So the situation is evolving more quickly than the concept. And I think if we want to have a categorization of countries for the climate crisis, we really need to look at things like annual emissions, cumulative emissions over time, the trajectory that these countries have for their future emissions. Are they going up? Are they going down? what kind of capacity do they have to mitigate climate change, to reduce greenhouse gas emissions, or to absorb emissions through their carbon sinks. We need to look at the technology and the finance and the ecological capacity that they have for adaptation. We have to look at their vulnerability to climate change, to sea level rise, or to killer heat waves, to food insecurity, to inequality. But I think we also have to move beyond the basically economic measures that are used to classify countries, because it ignores the ecological wealth of tropical countries, for example. There's this notion of, okay, we have the rich countries and the poor countries when we're talking about GDP per capita, for example. But what about ecological wealth? The ecological wealth of the planet is largely located in the developing countries. And those are where we find some of the most effective carbon sinks for absorbing greenhouse gas emissions. And because if you have greater biodiversity, you have more capacity to absorb. This also means greater vulnerability to climate change. So I think if we engage in a blame game about who's responsible for emissions, it's going to detract from our capacity to actually address the problem that's going to affect all of us. And now I want to move on to the topic of WTO differential treatment, which is known as special and differential treatment. And a lot of it is soft law. A lot of it is transitional periods to give countries more time to take on the obligations that were negotiated in the Uruguay round. But here, the problem with the categorization is that the three categories of member, developed, developing, and least developed, developing is self-selection. There's no definition. So any country can say, I'm a developing country, and that entitles them to certain transition periods and to certain considerations, even though they're mostly soft law considerations. And so that's problematic. Singapore, for example, which has twice the per capita income of the I should say 50% more per capita income than the United States, is a developing country in the WTO system. The least developed category does have a definition, but it's the United Nations definition. And it's mostly based on economic measures like GDP and per capita GDP. So it's a very crude categorization of countries. And we need more detailed criteria, and the criteria have to be adapted to the specific issues. So here I want to look at the example of pharmaceutical patents. For countries to have the obligation to protect pharmaceutical patents, it has to make sense for them to have a market that's big enough for pharmaceutical companies to actually earn money from those pharmaceutical patents. And you also have to consider whether they have manufacturing capacity for pharmaceuticals, what kind of disease prevalence they have, because you have to do it based on the disease. You are going to look at GDP and per capita GDP, because that determines whether the market is even worth insisting on pharmaceutical patents. But you also have to look at economic inequality in the markets. Look at the Gini coefficient, because if you have a lot of inequality, you can have a very small number of the population with enough money to pay for expensive pharmaceuticals. So that's just an example of how you need to tailor categorizations of countries in terms of the obligations they should be taking on according to the issue, and a very specific issue. And in the WTO context, this whole categorization of countries, I would term a neo-colonial system of categorizing countries. So we have a neo-colonial categorization for a post-colonial world. And one symptom of a post-colonial world is that you have big developed countries who don't really need to have special and differential treatment. And you have big developed country members who see differential treatment as a transitional period that permits developing countries to graduate to becoming more like the developed Western nations. That's also a problematic view of how the world works. I read a book recently by Heinrich about the weirdest countries in the world. Weird stands for Western, educated, industrialized, rich, democratic countries. And these are the countries that are behind these kinds of classifications. And the expectation really implicitly is that the rest of the world is on the way to becoming more like these countries. I don't think that's necessarily the case, and I don't think it's necessarily desirable. So the result in the WTO context is we have one size fits all rules that do not fit all. We have gridlock in negotiations because countries use these categorizations to put forward claims to what they're entitled to. Because the negotiations don't advance, we have a collapsing dispute settlement system in the WTO. And the intellectual property rights system tends to serve the weird countries, which are in the minority in terms of population. To some extent, big developing countries. But if you look at pharmaceutical products, and if you look at intellectual property rights for climate-ready crop genes, those serve the rich countries at the expense of the poor countries, and the poor countries are the ones that have the greatest need for these technologies. If we look at the international health regulations, we don't have differential treatment rules that are developed to the extent that they are in climate and in the WTO. It's really more about encouraging developed countries to help developing countries financially to address different health concerns. The main focus is on requiring countries to report outbreaks of diseases of international concern. But once you declare that, you risk trade and travel restrictions being imposed. And historically, the trade and travel restrictions have been imposed on the developing countries more than on the developed countries. So you have a requirement that creates a risk that has a disproportionate effect on the global south. And developing countries are more vulnerable to pandemics as well, because they have less capacity to fight pandemics. We've seen this in the COVID pandemic. Weaker healthcare systems, informal economies that exclude a lot of the population from the healthcare system and from social security systems, less access to medical equipment, less access to pharmaceuticals. And the COVID-19 pandemic has demonstrated very clearly the danger of relying on the kindness of rich countries to help you out in a global crisis. So when we compare these three systems, we can see that differential treatment is not helping to bridge the gaps in any of the systems. It has not resolved the problem of multilateral negotiation failure at the WTO, or the difficulty of multilateral negotiation in advancing adequately to address the concerns of climate or pandemics in the climate regime and the health regime. And a final point that I want to make here, and I think it's the more difficult point, is I want to ask, to what extent can we draw upon cognitive science to help us address these problems? If we look at cognitive science with respect to human behavior in relation to climate change and in relation to public health measures in pandemics, we see that there are cognitive biases that explain what seems to be very odd behavior. In the context of COVID, refusal to use masks or refusal to get vaccinated. In the context of climate change, denying that climate change is real, for example, denying that there's any reason to take any action on climate change. It is similar cognitive biases that influence individual responses to climate crisis and pandemics. And if we look at cultural cognition, that helps us to understand how different societies, it helps us to see how different societies can respond to laws in a different way, and can conceive of law and can conceive of what is fair, for example, in different ways. So the real question here is, if cognitive science affects individuals, how can we incorporate cognitive science into improving the rules in these multilateral regimes. And if you look at, there are some scholars of international law like Tomer Brood and Anne van Aken who have talked about behavioral international law, but it's really a subject that's in its infancy. It's only come up in the past decade and very little. But the question is, if we have differential treatment that doesn't base categorization on the nature of the issues being faced, on the nature of the legal regime that we're dealing with, or on the cultural cognition of different countries, or the capacity of countries to address issues, it should come as no surprise that our differential treatment regimes are failing. So I think it's an important issue to address, and we really have to try to fix this. But what we're seeing right now is we're seeing a migration towards regional trade agreements because the multilateral trade regime is falling apart. And my question is, will we see a similar migration towards regional climate regimes if multilateral negotiations on climate change don't advance quickly enough? And will we have more movement to regional health regimes as well, because the multilateral system is not addressing these issues effectively? If we take the example of pandemics, there's very close cooperation between Canada, the United States, and Mexico for pandemics, for example, and with respect to trade and with respect to environment. And the question has to be, to what extent can we deal regionally with global issues? But when we look at regional approaches, one thing that tends to be missing is differential treatment rules. And so the question is, do they serve a purpose at all, or are they simply an obstacle to more effective governance on climate and health and trade and intellectual property rights? So that's all I have to say today. I'm looking forward to the discussion because this is very much at the early stages, this area of research for me, and it's a challenging area to move into. So thank you very much for your attention.
Thank you so much. I didn't even have to use the stop sign, so you were ahead by 3 minutes actually. So that was really interesting, and I will hold my comments and questions until later. So our second speaker is Rodrigo Camarena from the same institution. Where is Rodrigo? And he is an assistant professor at ITAM in Mexico City. He holds a Bachelor of Laws from University of Guadalajara, a Master of Jurisprudence from University of Sydney, and a PhD from Macquarie University. He's a member of the Mexican National System of Researchers and the International Society of Public Law, among other research networks. His research focuses on theories of precedent and judicial decision-making, localization of law and legal education, rights of indigenous peoples, and Mexican constitutional law, particularly autonomous constitutional agencies. He is going to speak about Judges sans frontières towards a theory of globalization of legal ideas. So over to you, 20 minutes.
Thanks so much, Simul, and thanks also for the organizers and to Cassie for the help with the technology, and for the people that are getting online to discuss this. So I will share my screen. And I think let me just 1 second. Okay. There. Okay. Well, yeah. Also, thanks to Brad for the initiative for making this panel, and Francisca, both friends and colleagues at our university. Well, yeah, as Mudo told us, I'm going to talk about Judges sans frontières. That's the topic of my presentation. and the possibility of a theory of localization of constitutional ideas. So I'm going to talk something that was raised also in the plenary session. I think it was Alexandra who mentioned a little bit about transplants and the debate with other methodologies as universalism and functionalism. So in the last 4 decades, there has been a debate about how can we use foreign ideas in new contexts. And in the last 2 decades, this discussion migrated from private law to public law, and it has become very rich, and particularly in an intermediate position between the universal and the particular. So the universal is about universal justice and universal knowledge, and the local is the argument that law is context sensitive, law is relative to each context. But between, there is a very attractive intermediate position, and I think one of the most famous is Vicky Jackson and her engagement theory. So I'm gonna ally with this intermediate position, but I'm gonna try to contribute using the idea of localization that has been also popular in the humanities and cultural studies for at least in the 90s. And this is exemplified with an interesting case of Mexican constitutional law in one discussion regarding abortion. In that discussion, one proposal of one judge that was finally rejected, instead of looking to Brown and Board of Board Education or Roe versus Wade from the American constitutional law, he used the Lakshmi case from the Nepalese Supreme Court regarding abortion. His proposal was rejected by the majority, but it was a very interesting argument about understanding abortion through the experience of Nepal and substantive equality and actually transformative equality as the judges understood. So that's the main question. How can we deal with the local and global interaction in this time? So I think there are at least 4 lessons, very important lessons from this literature. There is from different perspectives. One is the perspective of legicentric theories of globalization that ask about how legislators or framers or ratifiers design a constitutional law. And one of the very important lessons that I learned is the idea of Gunther Frankenberg that the point of origin is blurred. He follows Edward Said, saying that if we want to analyze the origin of an illegal idea, it would be really hard actually to pinpoint where is the beginning and who is the author. Now, for instance, what is the origin of rule of law, of a constitution, of separation of powers? We can find different origins and different nations. Then there is a second very interesting point from concentric theories that focus not on legislators, but on judges or courts. Vicky Jackson and Suji Children are maybe the most famous. And Children says that conscious or not, when judges use foreign precedent, they are using a kind of analogy between cases that is common in any kind of precedent, but very interesting in foreign precedent. That is drawing an analogy between the principles and the values underneath and the particular history of each nation. So he draws, for instance, the analogy with untouchability in India and current discrimination against homosexual unions. So he says this is something similar, that kind of social exclusion that we now consider unconstitutional in India, and it will be something similar in current times when the High Court interpreted the criminalization of same-sex relationships in India. And he proposed analogy to make this this transition from the local to the global, and in a judgment that talked with South Africa, with United States, and with Fiji. And there are two very important lessons from the social legal, not strictly legal, sorry, not strictly legal literature. There is from legal anthropology or social legal studies. One is the idea from Teresa Aguirre, an anthropologist from Mexico, who makes the case that local and global are not necessarily coextensive to national and foreign, or national and global, making the case with indigenous people in Mexico who are Mexican, but they see Mexican and state law as foreign. But at the same time, they use this foreign law to make their political or legal cases stronger. And finally, the landmark work of Sally Ingle Merriam, who just passed away last year, about the strategic use of global and local ideas to make changes in a new context. And she talks about packaging or translating foreign ideas to local contexts that have local impact. These are, I think, four very important lessons from the literature, but I think that something is missing and could be really useful, or at least interesting to look at. And it's that each step in the drafting or a provision, or in the interpreting of a provision, it's already local, in the sense that it's a constant interaction of the global and the local, and it's difficult in some stages to draw a difference between what is foreign, what is local, what is national, what is from other jurisdiction with this interaction. So I think I want to make two claims. The first is, I think, a descriptive claim. That is that law is already a global phenomenon. We know about Hans Kelsen and Dworkin in Mexico, probably know that some people in the United States or in Austria. Our legal education and our legal institutions are full of global influence, but at the same time, we are interpreting this in a local context different. We are using Dworkin to understand our Mexican constitution, our Mexican rule of law, if there is some rule of law. So this is already there. This is most of the objective position in which we are in. But at the same time, from the subjective perspective of how lawyers work or how lawyers live their life. So for taking an example of my colleague Chisca, she's a Spanish national. I don't know if she identifies as Spanish or more Catalan. And she studied at Yale University, and then she worked at the Supreme Court in Mexico and as a clerk. And also, a clerk in Mexico is different than a clerk in the United States. And she's an expert of Mexican law and comparative law. So we see different layers of locality, of interaction of global and local, and it's difficult to pinpoint the one just local or national origin. So that's the descriptive claim. And then the normative claim, I know I need to work to strengthen my case of my previous portrait, but if law is already mostly local, then my normative claim is that it should be as transparent as possible, that kind of locality, that kind of interaction between the local and the global in each interpretive step. And I focus particularly in judges and judicial interpretation to stress the individual agency of agents of one subject, but also the interaction with a larger culture that is limit or that limits our own claims. So let's talk about these 4 steps as brief as concise as possible. Take the case of the nipple case used in Mexico. The case was about a mother that didn't want to have a 6th child, and she had the right to an abortion in Nepal, but it was costly, so in reality, she didn't have any right. So that's the context in Nepal, but we can't understand that present without first understanding that abortion was already legal in Nepal because of a transnational movement of rights, of feminist movement inside Nepal and outside Nepal. And we can't understand the judgment without the reference to Roe versus Wade. And at the same time, we cannot understand Roe versus Wade without the international movement that put in the case in movement in the 70s. People from the States going to Mexico to get an illegal abortion, and now it seems backwards. People from Texas going to Mexico City to get a legal abortion. So this is our intermingled since the beginning, and it's useful to understand this always in this interaction. Then we have an interpretation that is, I think that's what happens unconsciously most of the time, but the point is to make it consciously, to be conscious that we're interpreting in this interaction of the foreign and the local all the time. And following the Lakshmi case, it's interesting. First, well, obviously that the original judgment was in Nepali. And the court didn't cite the Nepali judgment, obviously, but also didn't cite the English version that we can find online. They cite a book chapter published by Pennsylvania University, written by Nepalese slash British lawyer who studied in the States and in Canada. So that's the kind of translation or mistranslation that we get when we receive, because we couldn't read, at least I wasn't able to read it, and something got lost in the translation, but also there's some sort of transnational interaction. No? Oh, great, I'm going okay, I think. Thanks. And then also the context. The problem in Nepal was about getting an abortion, even if it was already a right. It wasn't about the Mexican discussion about if it was a constitutional right or not. That discussion was already over in Nepal, but it was very interesting, the judgment, because it says that we have a right, but we cannot exert it. So that's very important for the Mexican reality, where we have lots of rights, but no reality. There's a gap between the text and the reality. And then I go faster with the 3 and 4 levels. What we try to do is trying to form alliances between our colleagues in our same nation, but also with other structures beyond our borders. And then we try to make a balance, as Uncle Mary said, between what is local and what is global. But the point is, it was already local since the beginning we're just trying to be as strategic as possible to show this in a familiar package and to reach our goal, that is in the goal of a judge, a good interpretation of a provision and a good solution to a case. So, and now just to end, this is a constant interaction between cultural and epistemic limits when judges are using foreign ideas. There is limitation, of course, about our own knowledge. I cannot read some foreign languages. Even if I can read some English, it's my second language. So there's limitations. But at the same time, those are regular epistemic limitations that we can find tools to overcome. We can find, for example, a center of Nepal culture in Mexico, or we can hire a clerk that knows how to do real comparative law in Nepal. So we're moving without and between frontiers, trying to better grasp or have a better argument about a constitutional case as informed as possible, even if that's difficult, but not that different to a common everyday discussion of precedent. And that's the end of my presentation. And I would love to discuss more about this. Thank you.
Thank you so much. You guys are so good with time. Excellent. So our third speaker is Francisca Poe, who is an associate professor of law at ITAM, Mexico City, where she teaches constitutional law, comparative constitutional law, and anti-discrimination law. She holds a law degree from Pompeu Fabra University in Spain, and a master's and a doctoral degree from the Yale Law School in the US. She has been a visiting professor in Colombia, Argentina, and Italy. Before joining the ITAM faculty, she was a law clerk in the Mexican Supreme Court for 8 years, where she had the opportunity to deep into regional practices of constitutional adjudication. Her writing focuses on courts, judicial review, judicial communication, institutional design, constitutions, constitutional change, comparative study of Latin American constitutionalism, and fundamental rights. She's currently coordinating with colleagues a project on gender and constitutionalism in Latin America, and one that explores the intersections of proportionality analysis and equality, social rights, and transformation in Latin America. That sounds a really fascinating project, I must say. Her topic is global proportionality canons from Latin America. So over to you.
Thank you, Smudo. Thanks for hosting us today. And in general, thanks to the American Society for a conversation among colleagues that we rarely have. All right, because we are always in different things, and especially with the pandemics, we haven't been meeting often, and we had these topics that have overlapping points of interest. As Brad, the same occurred to me with a plenary panel, right? And I thought that I have been recently working as well on constitutional taxonomies in comparative law, and all these categorization things. I think a great agenda for future work is already emerging with only 2 panels. But yes, as you said, I've been working recently on proportionality analysis, both on this book that addresses the historic and contemporary uses of proportionality in Latin America, particularly in equality and social rights arena. And I have written a chapter on a book about new global canons in comparative constitutional law. Of course, understanding canons, not in a kind of sacralized, authoritarian kind of way, but in a functional way, in the sense of thinking about the collection of materials and rulings that we take to anchor, right, our comparative conversations. And that is what I will talk about today. And in particular about the need to, about emerging standards, in this case in Latin American proportionality analysis, and the need, the advisability of taking more seriously the task of incorporating these global South emerging legal standards into the global canons. This is to say, incorporating real global practice into the academic and professional portrayal of global practice. Sometimes, by the way, the standards are not emerging, they have been there for long, maybe for decades, maybe for more, only that they have been invisible to the comparative conversation. And I think we should do this not only because it is good for the discipline, not only because it's good for academic inquiry, for building a more equalitarian structure of legal knowledge, but also because it will help us solve problems, because it is good for the world, because the problems we are confronting, it can be, neo-authoritarian populism, it can be the COVID pandemics or other type, climate emergencies, I think have been addressed more often in non-central countries than in North Atlantic democracies, right? So this is why awareness of standards of the global South is a good idea, I think, because in a way, problems that have been, usual among us are kind of globalizing, right? In the domain of proportionality analysis, this phenomenon is really clear, I think. It has been repeatedly remarked that, proportionality is a staple of global constitutional law. The narrative of the global expansion is very well known. It apparently, then, according to this narrative, proportionality is used basically at the beginning by German courts, Western European courts, when they restore constitutionalism, rights-based constitutionalism after the Second World War, and then with the transition to democracy of Central and Eastern Europe, proportionality is adopted as a mainstream methodology there. And then in the 90s, of course, it expands to Latin America, which is doing at the same time, the legal and political transition. And then it is adopted also in South Africa after the change of regime in the 90s. And then it emerged in Israel, thanks to a judge that, Rodrigo has been talking about, the kind of role that this kind of judges have. And then, even it's been expanding to Taiwan or Hong Kong or South Korea and, the countries. And even, I don't know, Brad, what idea has, but even, the narrative, the global narrative of proportionality portrays how it is even used or was even used in the World Trade Organization and, in the evaluation of trade and investment law, etc. Of course, it has also expanded to international human rights tribunals like Strasbourg, the Inter-American courts increasingly. But the thing is, what I want to stress is that notwithstanding this narrative, in actual fact, the descriptions of the practice and the theorization of the practice is largely based or almost exclusively based on examples drawn from a handful of countries, namely those of the global North or those of the global South that use English as vehicular language, right? So, and this is problematic. This leaves in the shadow entire ideas of actual practice, and it often leads to non-accurate conclusions about, global proportionality. for instance, it's common to see scholars affirming or reflecting or underlining that proportionality is not very used in the domain of social rights because it's not deferent enough, right? And so people say, well, in the domain of social rights, you find far more deferent methodologies. When in Latin America, you know, the most used, common use, at least in the countries with strong constitutionalism, and I will talk, of course, about Colombia a lot in the minutes that will follow. It's used basically in social and equality rights cases. Sometimes it's said, you know, in prevailing scholarship analysis that proportionality is not used in the domain of division of powers, you know, only it's used only in the rights domain. But in Latin America, we have a very long tradition of evaluating emergencies, evaluating states of exception, you know, which basically police division of powers issues between the parliament and the military and the executive. So this is also, you know, not accurate enough. And then, for instance, I see also a lot of analysis saying that portraying proportionality and reasonability as separate standards, you know, as different traditions, when the fact is that in Latin America, for instance, we have a tradition of proportionality analysis that is called reasonability analysis, and that, you know, methodologically analyzed is a kind of hybrid, or it can be different things, right? So, so this is the thing about trying to enrich the global canon from Latin America. And it's important to see in what ways this project is different from building a Latin American canon, right? Because if you want to build a Latin American canon, for instance, it can be of interest, you know, to gather materials and rulings and legal production that, for instance, trace the historic origins of the scrutiny in Latin America, or that, you know, reconstructs the role proportionality has played in the political and legal transitions of the region, or analyze how proportionality has, for instance, played out in some of the debates that have been central in the region in recent times, such as the debate on abortion or the debate on same-sex marriage. But the idea of expanding the global canon is different, right? Because maybe, you know, the Colombian ruling on abortion is very important to understand the debate on abortion in Latin America, but it might be that it's not particularly expanding anything at the level of, you know, emerging global standards. If you want to enrich the global canon from Latin America, what you want is to integrate materials so as to make the portrayal of global practice less incomplete. You do not, and this is why it is a slightly different project of Rodrigo's project, I think. Of course, the two are very relevant and equally important, but in this case, you don't want to track the translation of the global into the local, or the other way around, or to track this intermediate space, Rodrigo, that you very interestingly have put on the table. But what you want to do is to build a new global, more truthful to the name, right? So it's interesting, not to try to, listening to you, to try to contrast the different things that we are trying to do here. So I think Latin America, in this sense, gives us the opportunity to see how proportionality works in constitutions that are in important dimensions different from those that prevail in the global north and that have been taken, you know, as the norm, right? The global canon can now incorporate how proportionality works in constitutions that are long and detailed, not abstract, you know, not the US style. And you know, and probably a lot of contemporary constitutions are long and detailed. You know, why see this as something? It also has to do with the Rodrigo remarks. I mean, why the US Constitution must be the standard, you know, a super abstract things written by 2 centuries ago. Why should we see, you know, the Constitution of India, which is extremely long, and why should we see the Ecuadorian or the Colombian Constitution or the Mexican Constitution as an anomaly? Or why should we think that, you know, global practices are those that have been built, assuming the US Constitution or the German Constitution? instead of. So this is the first area of opportunity, how proportionality works in detailed and long constitutions. And I mean, I could expand on this and why this is not an anomaly, but I won't do it because otherwise I will be the one that will be cut by our host. Second, I think it gives us the opportunity to see how proportionality works in constitutions that confer the same status, the same enforceability status to social rights and to civil and political rights, you know, and this is very characteristic of global South constitutions, you know, like social rights are for real and they are positively enshrined in the same way. And, you know, and instead of, you know, in this kind of, I don't know, a directive kind of positivization that we find often in post-war constitutions of the global North. And third, I think it gives us the opportunity to see how proportionality works in constitutions that contain asymmetric mandates of special protection for disadvantaged groups, right? And this is always it's very nice to track how proportionality analysis adapts to, you know, to give teeth to these mandates of special protection. So in the chapter that I am trying to summarize here, I see then three sorts of expansions of the global canon of proportionality coming from Latin America, coming from its use under the sort of constitutions that I have described. The first one, and I will be also very brief, of course, then I can circulate the stuff. The one is a methodological expansion that I think it's interesting. The second, more interesting even, is the functional expansion of a proportionality analysis. And the third is a thematic, I don't know how to put it, substantive expansion, right? What I mean by, very briefly, methodological expansion. I think the use of proportionality by the courts of the global South shows a particularly concern for grounding or methodologically explaining what the court is doing, right? As we know, you know, Alexi has been very important, but Alexi has had alumni that have very interestingly developed proportionality analysis theoretically with, you know, having in mind problems of the global South. But then there's been these methodological developments in the courts. And so it's interesting because one of the criticisms of proportionality analysis is, you know, the criticism of the discretion, right? That allows judges to be, you know, allows too much freedom, you know, to judges, and does not allow like the screening of the reasons so well. And this is interesting because here we have courts that not only want to create a culture of justification in the other branches through the use of proportionality, 5 minutes, great, thanks, but also that care to justify what they do in methodological terms. You don't see usually these methodological developments in the rulings of the global North. So this is, and in this chapter, I pick up, of course, the great rulings of the Colombian Constitutional Court developing the integrated proportionality test, which is a kind of, you know, a lecture on comparative law. It's a book over there, or the regression tests that, you know, some of the participants in the book I have coordinated, and that will be out hopefully next year. They just, you know, show all the unbelievable methodological development on how to analyze regression, right? The second, functional expansion. There are three kinds of very interesting functional expansion in the global South. In Latin America, in Latin America, let's leave aside the others. In Latin America, courts use proportionality analysis to review not excessive action, which is what, you know, the German courts or the Canadian courts or other courts have typically done, but to review insufficient action, omissions, states that do not do enough. Not, you know, public authorities that do excessive things and then violate my rights. It's the idea of violation of rights by omission or insufficient action, which I think is extremely relevant after the COVID pandemics, because one of the problems of the COVID pandemics is having, Trump doing nothing or AMLO doing nothing for the most disadvantaged people. So I think this is, again, something from Latin America that
Oops, we seem to have lost her. Let's give a couple of minutes to see whether she will rejoin us.
Sometimes we can have a power outage all of a sudden.
Right.
That might be the explanation, but it could be something else.
Okay. So do you guys still work from home?
Yes.
Okay. All right. Yeah, we are back in person now.
Yeah, we're
Teaching.
doing hybrid classes. So we have
I
some
see.
students online and some students in the classroom.
Uh-huh.
So we go to school to teach, but then we tend to be doing the rest of our work from home.
I see. Okay. She's coming back in a minute. Thank you, Rodrigo.
Perfect.
Yeah. Yeah, this is the peril of relying on technology. Yeah. But, what would we have done without technology? Oh, she's in the waiting room. Okay.
I'm sorry, it took me out.
Oh, really?
Can I wrap up, or it's can I
Yeah,
wrap?
yeah. Go ahead. Yeah.
Okay, sorry, I'm sorry.
That's
just
okay.
Yeah, so the first is this kind of, to control insufficient action. The second is the control of regressive action, which I think is also very interesting now for the entire world, because, we will have regressive action in many cases, because there's, economic crisis or whatever. So you have public policy going backwards, and in Latin America you have proportionality tests evaluating the regressive action. And then, well, there's another thing that is more complicated, but I find it also interesting, is the expansion to evaluate continued optimization of rights, right? But I don't want to take a lot of time, and I can explain it later. And of course, the third kind of expansion is topical expansion, thematic expansion. And here I analyze rulings that apply proportionality, for instance, to problems of transitional justice. Extremely interesting, which use, balancing justice, peace, and the rights of the victims to truth, for instance. And then, of course, the other area of thematic expansion is social and economic rights. And if you think about it, most leading cases in proportionality analysis from the North are not social and economic cases. I mean, Regina versus Oaks in Canada, is not. I mean, the Israeli cases are not. The South African leading case is Makwaniame, I don't know how to pronounce. The death penalty case is not a social case, right? So I'm very sorry for the interruption, the technical problems, but I will leave it here. And, of course, I can circulate all this work, and I really appreciate the opportunity, of discussing it, and also all the other topics that my colleagues have put on the table. Thank you.
Thank you so much. And we are so happy that you came back. So you were wondering what happened. So thank you so much for these three fascinating presentations. So for the audience, if you have questions, please put your virtual hand up and we'll get to them. So to start with, I had a question. Actually, I have questions for all of you. So I will post them right now. I don't see any hands up yet. So for Bradley, this is something that I have been studying, the common but differentiated responsibility principle in relation to environmental issues. And, you know, it's not just about who contributed to the problem. It's also about who is vulnerable, who is capable. So there are different ways that this principle has been given effect. So not just differential treatment in terms of obligations, but also establishing funds to help developing countries, giving, you know, different phase out periods, technology transfer and things like that. And you're totally right that this distinction between developing and developed countries is totally outdated, and we can no longer rely on that. You know, a good example is China. You know, is China a developing country? And it has sort of taken advantage of this notion. For climate change issues, it is a developing country. For economic issues, it's not. So in your opinion, how should differentiation be done? Because I think it's necessary, because we cannot treat, particularly in issues like climate change, health, and trade, things that you discussed. And, you know, in relation to many other issues, there has to be differentiation. Those who contributed more should be held more accountable, obviously. So how do we ensure that, you know, justice is done? How should we ensure differentiation in a different way? Because, you know, differentiation is important for developing countries when it comes to climate finance, climate adaptation. So how can we do that? To Rodrigo, with regard to comparative law, I was wondering whether you had looked at, actually for both of you, with regard to comparative constitutional law, environmental issues. And that has been one of the areas where, you know, both constitutional law and human rights law have played a huge role in articulating environmental rights in the absence of a right to a healthy environment until recently at the international level. So I would be keen to find out with regard to, in relation to Francisca, how proportionality has played a role in relation to environmental rights, in articulating environmental rights. And how, Rodrigo, how comparative constitutional law plays a role in relation to environmental rights. So I'll leave it there. If you want to answer now or gather a couple of more questions. There is one hand up.
It's me, but only in case that no one else raises their hand, so we can. I can wait for a minute.
Okay.
Yeah, go ahead, Ed. And actually, you have a question, Rodrigo, or do you want to answer?
No, I can wait. I can wait and hear Brad, Francisca, and if someone in the others want to ask, I prefer that. But in case that we have time, I have some questions for later.
So who wants to answer my questions? Who wants to go first?
I can go first.
Okay.
So I understand the question to be, you know, so how should we address differential treatment? Because differential treatment is necessary for developing countries. And I would agree that it is necessary. We both agree that it's been done badly. And I would say the way you have to do it is you really have to do it in a more tailor-made fashion. And so I would say you have to do it, you have to look at the individual country, you have to look at the issue, and you have to look at the regime that you're talking about. So I'll give two examples. If you take, if the country is China, and the issue is access to clean energy technology, and the regime is intellectual property rights, I would say the regime of intellectual property rights is not going to create a barrier to access to clean energy technology for China. So China has plenty of clean energy technology, is a leader in clean energy technology. And so there is no issue of barriers to access for China created by the intellectual property regime. But let's take another example. Let's take India and access to climate-ready crop genes or new plant varieties that are climate-ready, and the intellectual property rights regime. Well, there we're going to have a very different outcome. If we look at India, I understand that about 500 million people in India depend on subsistence farming to get by. And climate change is going to also have a very big impact on India. So if you don't have access to technology to make subsistence farmers more resilient to climate change, and that technology means plant-ready crop genes, it means plant varieties, it means the fertilizers that go along with that, it means the financing to acquire these technologies, then we're going to have very, very serious problems in India. And if we look at India, it's probably better for India not to be assuming some of the more stringent intellectual property rights regarding new plant varieties, because it's simply not in India's interest to do so. So you can see here, I've chosen an example of two countries that are very big countries. They're both developing countries, but the issues are going to play out very differently depending on what the issue is and what is the regime that we're talking about. Here we talked about the same regime, intellectual property rights, different issues within that regime in different countries, and we see that we get very different results. So that's just one small example to prove my point that it has to go beyond these very crude categories of developed and developing, or developed, developing, and least developed. And it really has to be broken down in a much more granular way.
Thank you so much. Rodrigo, Francisca?
Go ahead, Rodrigo, if you want, and then me.
Thanks for the suggestions about the environmental law. Regarding the connection about constitutional law and transnational law locally, I know very little about environmental law, but I'm very interested, and I will be interested to follow the discussion in two topics in particular. One is the intersection about state law, indigenous law, and the indigenous views, and transnational law in general. And it will be nice to hear the suggestions or more about that. And the second that I'm very interested, actually, about a long time ago, I read about the famous case of Indian case of punitive damages, the Bhopal case, if I'm correct. I think it's very interesting, that kind of transplant or global migration of punitive damages to Mexico in environmental law, because it's a very interesting clash between the private law and the public law. And I think it's a potential tool for Mexican law against pollution that hasn't really kicked off in our country, among other things, because of bad judicial interpretation and a bad legal framework. But those things come to my mind that will be really interesting to follow the discussion.
Should I respond?
Yeah,
respond briefly, and then we go to the other questions. No, I before responding, I have a comment for Brad, because I think your project, Brad, is really central to this seminar, right, to the topic, because you are really doing comparative international law, right? I mean, you are comparing trade law with climate change law, with intellectual property law, right? In this case, you are interested in mapping how these different international areas of international law deal with the rule of differential treatment, with something, of course, I was completely ignorant of, and I've learned a lot. But I think as a project, this is super interesting. right, look, they have different ways of using this rule, but on the top of it, we should completely change the way it is different. But maybe in different areas of international law, we should do it differently, right? Now, so I just, listening to Elizabeth Trujillo this morning, and now, I mean, I think your paper is really central to this, to the overall topic of the seminar. And also because, from the ignorance, I think this is extremely interesting. I've been working a little bit on drug policy, right? And in drug policy, with a co-author, it's very interesting to compare how different it is international prohibitionist, horrible drug policy, the treatise on specific treatise on drug policy, and how is the international health law. So if you frame drug use under if you use a health framing, applicable international law is completely different than if you use a different international law. That is why the project of comparing different pieces of international law, I think it's fascinating, right? And not anymore something that is not of interest to us, the constitutionalists, right? Because of course, this international law is constitutional law as well now. So it's a very simple comment, but only to say that that I want to read all this stuff that you talked about today. And your question, Somodo, is I don't have of course, Latin America has very distinctive developments in environmental constitutional law, right? We have these rulings in Colombia that recognize rivers and animals as right holders, right? And we have these rulings that treat the Atrato River and the Amazon River as a rights holder, and this habeas corpus in favor of bear, spectacled bear in Colombia, and so of course it's really interesting to map. But one thing that we haven't done, and I don't think our book it will be that useful, so we need another project. I don't know specifically how much proportionality has been used within. I don't see any, particular problems for the sort of use. I think it would be interesting, and I don't see reasons why it wouldn't be used. On the contrary, right? But most of the things that we see in the book and that we map out are social and economic, right? Like labor right things, not environmental issues. So thanks for the question, because now I see something that, we will have to research into more. Thank you.
Thank you so much. If I can add to that, some of the human rights committees, treaty bodies have used the proportionality principle in relation to environmental issues.
Okay, I will look into the resolutions.
Yeah. I have a book chapter in. I can send you the details.
Please do it. Please do it.
Okay, Elizabeth, I see your hand up.
Hi, everyone. Well, first of all, my apologies for joining the panel a bit late, and so I missed Bradley's presentation. Although good to see you again, Bradley. We've
likewise.
Yeah, we've been on panels before together, and I'm familiar somewhat with your work. This is a really fantastic panel, so my congratulations to all of you. Very interesting topics, and it's so refreshing to talk about and hear about these issues from the global South, and particularly from Latin America. And your comment about Francisca about the U.S. Constitution is not the only Constitution, right? The U.S. way is not the only way, and there's a lot of work and interesting things happening south of the U.S. border that many times we don't hear about in the U.S. So thank you for raising that. I guess I have a broader question, which is maybe you all can help me grapple with some of the things that I'm thinking about now in my own research, which is that, clearly we've had an international regime that has been focused on certain guiding principles and international rules about how to apply human rights, right? Or trade or environment. And within those regimes, we've struggled to find common threads sometimes because each regime has been so sort of focused on their own issues. But we have seen increasingly the need for more interaction between them, more understanding. They conflict with one another, they engage with one another. And particularly in the context of sustainability, environmental sustainability, we see the real need for that sort of combination under reconciliation between economic development and sustainable development. At the same time, we see a need for an understanding of the local and the global, which brings me to Rodrigo's point, which is his presentation I thought was really interesting as well, with this idea of globalization, because when you're trying to solve a problem like environmental sustainability, it's an international problem with local solutions, much like COVID, an international public health problem that has local solutions, and you need collaborations. And it really, part of the questions I ask myself is international law helpful to finding these solutions? And then I think about, Bradley's work and his comment just now in answering the last question about we have to think of these things in categories, and that's absolutely right. I mean, those are some of the limits of international trade regime, frankly, I find, because, we have these broad breath strokes about, trade and environment and understanding one another, but the actual problems around fisheries, subsidies, decarbonization strategies, border tax adjustments, emissions, they're very specific areas that are local, regional, and very different depending on the needs of the countries, right? So you cannot have a broad stroked sort of environmental regulation as applied in North America to Colombia or to India that depends on these types of subsistence agricultural farming, for example, and so forth. So long-winded comment, but my question to you is to think sort of if we can find a common theme in all of your presentations about how should we now think about international law? Like, what is the role of international law when we take into consideration all these different avenues and lenses through which we try to find answers to problems, real local problems? Do you have any thoughts about directions that we should be going in the international field? Does comparative law help us to answer that question? I kind of just throw that out there to see, to provoke some conversation and discussion and thoughts.
Well, who would like to take that question? Bradley?
Sure, I'll take that question. Well, thank you very much, Elizabeth, and it's very nice to see you too. And I really enjoyed your presentation in the plenary session, and I think it in fact helped me to start thinking a bit more and from a different perspective on my presentation today. And I think probably I'll start by sharing the thoughts that I had after listening to your presentation, which I mentioned at the beginning of my presentation today, which is why compare was the question I came up with, because I thought, okay, there's this question, why should we compare international law? And for me, with my topics, it's because they're all interconnected. They're not really separable. You can't say, okay, we're going to solve climate change without reference to the trade regime. We can't say that we're going to address global health issues without reference to the climate regime or the trade regime. So we really do have to apply all the rules of all these three regimes simultaneously to address these global issues. And secondly, you mentioned cross-fertilization. I was happy to hear you refer to that, la polinización cruzada in Spanish. And certainly your talk today was about this cross-pollination between trade and environmental regimes. And I think we actually need more cross-pollination between trade and climate and health regimes. And because I think there are lessons from one regime for another regime, and you can compare how different regimes address common issues that arise on a global basis. So multilateral negotiation failure at the WTO, for example. To what extent are there lessons from the WTO situation that might provide lessons for multilateral climate negotiations, or trying to advance global health law on a multilateral negotiation? To what extent, the topic of my presentation today, is differential treatment helpful or hindering when it comes to negotiation and when it comes to adapting global rules to local circumstances? And I think for me, these are the values in comparing international legal regimes. And there's a more traditional reason for doing it as well, which is conflict of laws. We want to see, is this regime going to conflict with this other regime? It's not something I talked to specifically in my presentation today, but it is something that I do analyze in my paper, is to what extent is common but differentiated responsibilities compatible with the WTO regime? And I don't think there's any problem there at all, and I'm sure you know why, right? So I think there are a lot of reasons for comparing regimes, and for thinking about regimes in an integrated way when we're looking at how we're going to address in international law, how to deal with specific problems that are global. So we can talk about climate; it's a global problem. As you've pointed out, the solutions have to be local for climate change, for pandemics. So we have to see, okay, where do we need to do this globally, and where do we need to do this locally, and how can we take global rules and adapt their application to local circumstances? And I think that's really where my focus is to say, differential treatment, yes, we need it, but the way we have it set up is simply not working, and the assumptions behind it are misguided as well and don't fit with the current reality of the planet on any measure, whether it be the geopolitical context, whether it be the assumptions about a colonial approach to global governance, whether it be about whether you need subsidies or not for clean energy, or whether intellectual property rights are an obstacle. It depends on the technology. So these are my thoughts on this and why it's important to do it.
No, you can go. I have nothing to add, only, I already said, for a constitutionalist, it's immediately interesting, right? Because constitutions are open to all kinds of international law, you know what I mean? So, so it's really interesting. Sometimes you can choose what international source applies to a thing, because this thing, as Brad has said, can be simultaneously seen under different prisms, which bring in different normativities. So, but other than that, at the level of international law, I have nothing to add.
Thank you. And if I may add, I think international law has a role to play, obviously, when it comes to global issues, because, otherwise, how else can we bring the states to a common platform, right? But at the same time, I feel the silo mentality that we have, both at the international level and at the national level, has given rise to all these problems that Bradley was talking about. We tend to sort of think of issues, climate change is an environmental problem without thinking about its impact on trade, human rights, security, So I think we need to sort of adopt a much more integrated approach to these issues. And as Bradley pointed out, think of the local impacts too. And we see this in relation to climate adaptation, for example. It cannot be a global issue. It's very, very localized, issue specific. So that's what I have to add.
If I could just add, thank you for all of your responses, really interesting. You know, it reminds me, I worked on a project with a lot of environmental lawyers on decarbonization strategies for the US. And I was working on the trade compliance issues. And, you know, the question was raised, what can trade do for climate change? And my response initially, just in sort of chatting about how to focus the project, was it's interesting because a trade lawyer would never ask that question, right? The traditional trade lawyer, right? So,
right.
And that in itself spurred on some very nice exchanges about, well, maybe we should be talking to one another a little more to find these solutions.
Exactly. Yeah. Sorry, Rodrigo, I think you had a question, right?
Yeah, well, I have two questions, comments for Bradley and for Chisca, and also a follow-up of comments from you and from Elizabeth. When Chisca said about the bear in Colombia, I remember there is a very interesting case from Argentina of an orangutan. And they won the case because in Colombia they lost it at the Constitutional Court, but in Argentina they won not at the apex level, but the intermediate level, as far as I remember. And it was huge because not only they recognized legal personhood of a great ape, but also they obtained liberty, the freedom that is different from other cases, including New York, where the discussion starts to develop about whether apes are persons. So I remember that really interesting case. And about the question that of Elizabeth, it came to my mind the very interesting work of one Peruvian lawyer, one Peruvian academic whose name is Roger Merino. He writes about comparative decolonial law in Latin America, particularly about the Constitution of Ecuador and Bolivia. And his main point is that we're still destroying the world because our constitutional framework commands it. Because we have constitutional provisions that understand nature as a resource that we need to exploit. And he has a couple of papers about that, and it's a really good work. And in general, there's a whole project in the Max Planck Institute about decolonial comparative law that maybe you are aware. I knew Roger because of that project, but other stuff I think it could be useful, that ideas to the international arena. And then my questions, and if we don't have the time, we can discuss later. It was about one from Bradley and one for Chisca. For Bradley, it was I wanted to know more about what are your hunches or your intuitions about cognitive biases in the developing of categories that are, I don't know, I think, for instance, the idea of there is some interaction between economic and cultural biases, in the sense that we assume that what the rich countries are saying is more clever, more original, more authentic, etc., than what the poor country is doing. And even, I mean, I accept it. Sometimes I myself, I'm part of that bias. So I would like to, or even the other kind of bias that I find Nepal more interesting than Mexico sometimes. No, that is also, I'm exoticizing another country. Well, just because of that. And to Chiska about the creation of a true global canon, my question is that my impression is what you mean with global is a truly universal, really universal, not something particularly that claims to be universal. And my question is, what do you think about some discussions in Latin America and the global south about the rejection of the idea of the universal? If we try to make a whole category for all the world and all the time and all different perspectives, maybe we're going to lose a lot. So they talk about the pluriversal. So I just want to know what do you think about that. That debate. That's everything, and thanks, everyone.
Okay, who wants to go first? Okay.
I'll jump in there. Yeah, I that's a really good question, Rodrigo. I think the cognitive aspect is really complex, and I'm only at the beginnings of trying to think about it. You know, on the one hand, the easy part of my paper is the part where I'm comparing differential treatment across 3 different regimes. That's the easy part. The difficult part is asking how cognitive science might inform the categorization of countries. When you read the cognitive science, it starts to help you understand why we have the defective categorizations that we have. But I'd like to try to go beyond that and ask, okay, can cognitive science not just help us explain the defects, but actually help us to construct something that's going to be more effective? And I don't have an answer to that question yet. But what I find very interesting is I mentioned the book, The Weirdest People in the World. And these are the Western educated, industrialized, rich, democratic countries. Chiska referred to them as the North Atlantic countries, which I rather liked as well. But essentially what it is, there's a historical explanation about the way that communities developed and institutions arose and markets developed in Northern Europe that changed the cognitive processes of the human minds in that part of the world. And from there, and this happened over a period of centuries, and it spread to the United States and Canada through colonization, and Australia and New Zealand as well. The way it got transplanted varied with the context. And then some of these institutions that came out of the weird countries ended up being transplanted into other countries that had a different cultural cognitive mindset. And sometimes it worked in those other contexts, even though they were different contexts. There were similarities in the development but in different methods. And basically you get this sense of there's such extraordinary diversity of how human minds have developed in terms of cognitive processes. And that really has a huge impact on the perception of the world. And I think there is a perception on the part of the weird countries, and I suppose partly because it's the propaganda of the weird countries to say, well, we're doing it the best, because in part that cognitive process has led to the creation of incredible wealth, but it's also led to incredible ecological destruction. So I don't think, even though there's been a big acceptance of the notion that the weird mindset is the one to strive for, both on the side of the global north and on the side of the global south that has bought that story, I think that we have to move beyond that and say, well, no, it's a very problematic mindset. It's leading to the destruction of the planet. And the assumption that everybody has to develop that same mindset, I don't see how that's going to get us to a positive place. So what we really need to do is we need to start valuing different values and different perspectives and different cognitive processes and especially cultural cognition, we need to develop a greater appreciation of these distinctions and this diversity, and understand how that diversity of the way the human mind functions is going to influence not only the development of norms, but also the way that norms get received in the culture. So it's a very complex process. I think it's something that's going to require some quantitative analysis and research. It's going to require surveys and that sort of thing. So it's a big task that lies ahead. And at this stage, I think I'm just trying to figure out the parameters of how that's all going to fit together, and then try to take the next step forward with some quantitative studies. But it's very complex, very challenging, and very interesting.
Okay, let me say something about very interesting Rodrigo's remarks. We've been talking right about the methodologies of comparativism, the goals, what should be the goals, about the object, and now Rodrigo invites analysis of the grammar, and which is of course strictly associated to your paper, and of course we have to build a new grammar, right? Because the analytic grammar that we have is biased. I've been now with people from all over the world, many of them from Asia, in a project about mixed constitutions, mixed constitutionalism, mixed regimes. And it is unbelievable how our grammar of constitutionalism just simply assumes that constitutionalism is liberal constitutionalism, and in particular abstentionist, non-equalitarian liberal constitutionalism. And so I couldn't agree more on the way of doing all these new comparative projects with the goals we've been speaking about. We have to build a new grammar, and I think I have to read the paper, but this local kind of thing for that you propose, it's appealing, right? It's like I am not particularly attracted. I don't know a lot about it, but all these, approaches about what you said in the end, no, the people that say that you cannot really build the universe. I don't know if it's an approach that speaks of unsurmountable cognitive barriers, to communicate. It's not appealing to me, because if we buy this epistemological, then the powerful guys will be there with the grammar, biased grammar they have always used. I don't think it's productive, in particular for the kind of thing that interests me. It might be true, but meanwhile, the epistemologies of knowledge and law I think we must really engage the project of transforming the grammar. The grammar of analysis is now biased, and we can detect that in many ways, and I think we increasingly do it, and so we have just to transform that as we advance. I don't know, but this I think you can say a lot in that project, because in a way this is the kind of thing that you're exploring now, with the project you presented.
Wonderful. So I think the time has come to decolonize grammar as well. We have 2 more minutes for the panel. Does anybody have one last question, comment? No?
Or somebody in the audience that wants to make some comment? We've been talking a lot already.
2 more minutes. No? Otherwise, I will thank the panelists. I mean, this was a fascinating panel. I learned so much, and I will follow up with some of you with some, literature on some of the stuff that was covered. Thank you so much, and I look forward to the rest of the presentations today. So,
thank you,
everybody.
Thanks, everybody. Thanks.